The shareholders agreement is arguably one of the most important documents for any company. It details how the shareholders are to interact with each other and with the company itself. But how should you structure your shareholders agreement? In this video, we'll discuss just that. Also, make sure to stay until the end of the video to find out whether a shareholders agreement overrides the Articles of Association in case of a conflict. If you're new, I'm Malcolm Zoppi, an English qualified solicitor, and I help UK SMEs with their corporate and commercial legal needs. Okay, great. So how should you structure your shareholders agreement? Well, I can give you three main things you might want to consider including in your contract. Number one, restrictive covenants. These are restrictions on what the shareholders can do. For example, shareholders should not compete with the company. Second, drag-along provisions. You might want to one day sell the entire company to a private equity firm or a competitor. That means that ideally all shares would be sold to that third party. If you include drag-along provisions, so long as a specified threshold of shares is met and willing to be sold to a third party, then everyone else can be dragged along to also sell their shares to that third party. And third, you might want to include a list of decisions that should be reserved for the shareholders and would require shareholder approval. As a top tip, you might want to consider paying particular attention to how you define shareholder approval or shareholder consent. There are two main approaches that you can take. Assuming that you are satisfied with a simple majority, meaning more than 50%. Number one, count all of the voting shares of the company and base your 50% calculation on that, which tends to be a greater number. Or number two, base your 50% threshold on the amount of shares that are actually present at a relevant general meeting. Now, before we discuss whether the shareholders agreement overrides the Articles of Association, feel free to send me an email if looking for professional legal advice. Okay, so which document overrides which? In short, the articles override the shareholders agreement unless the shareholders agreement has a clause in there known as the supremacy clause that says that the shareholders agreement overrides the articles. Great, so you've learned a little bit more about the shareholders agreement and the kinds of provisions that you might want to include. Another strategy that you might want to consider taking is the issuing of different classes of shares. And to learn more about different classes of shares, make sure to watch this video right here.